judgments, and that's a curtailment of
घबराहट क्यों हो रही है अगर राइट टू अपील मिल गई? आप एज अ पॉलिटिकल पार्टी आपको क्या फर्क पड़ रहा है? हो सकता है आप फायदे में जरूर किसी केसेस में
जरूर। फिर आप ये दो जजमेंट्स मैंने दी हैं सर, इनको भी ओवररूल कर दें, प्रोविंस को भी।
आपसे मैं पूछा एज अ पॉलिटिकल पार्टी आपको फायदा या नुकसान क्या हो?
फायदा नुकसान की बात नहीं
हो रहा है तो बता दें।
कोई फायदा नुकसान नहीं है, सिर्फ the only concern is that Parliament and my client today it's going through difficult time, but it can be in power again. It can be in power again. The history of Pakistan teaches us this. So even then I am under instructions to say that this is not something that the Parliament should be allowed.
ये जो बात आप कर रहे हैं ना, I am under instructions to state, sorry, हम ये बिल्कुल नहीं एक्सेप्ट करेंगे। इस किस्म के केसेस में you are not under instructions. You have to assist the court. I can say stand on your head or whatever. I'm not concerned with that. This is not his rights or that party's rights that we're talking about, that you can give instructions. जब आपने ये तय कर लिया है कि कोई उनका इंटरेस्ट नहीं है, तो फिर आप ये नहीं कह साथ साथ I'm under instructions to state. Sorry to say आप मातहत नहीं हैं. You are an officer of this court first and foremost. And in this case, the matter ends there. Doesn't go beyond that.
My lord, that goes, Your Lordship, when I first stood here on the last date, Your Lordship asked me a question, who are you with? And I said, I'm supporting the petitioners, but with some caveats. That's all I'm saying. That all that I've said, the legal submissions I made are not
instructions का लफ्ज़ ना इस्तेमाल करें.
I'll take that. But the position is that Parliament does not have power because it इस कोर्ट पे इसी कमरे में फिजिकल अटैक्स भी हुए हैं। पार्लियामेंट में जो होता रहा,
सॉरी प्लीज
उसके लिए आप पार्लियामेंट, इसीलिए ये फायरवॉल क्रिएट की गई है अगेंस्ट टू प्रोटेक्ट द जुडिशरी। दैट्स ऑल आई एम सेइंग। पार्लियामेंट अपने डोमेन में रह के हजार चीजें करे,
हम प्रोटेक्ट करना चाहते हैं पार्लियामेंट को भी।
जरूर करें, मैं आई एम ऑल फॉर इट। इसीलिए तो मैंने आपको एंट्री 55 में से एक रास्ता देने की कोशिश की है, which goes against what the case law of this court says.
Under the constitutional scheme, each organ of the state has been provided power to make its own rules. The judiciary doesn't make the rules of the parliament. The judiciary doesn't make the rules of the executive. The judiciary makes its own rules.
Yes,
right? Only those rules made by the executive or other organs which are in conflict with the constitution can be looked at by us, and if we find they conflict with the constitution, they have to be struck down. So those three firewalls have been intentionally, deliberately created by the Constitution, and the interest of every citizen of the state is that they remain intact.
And there are unanswered questions.
Yes.
Is that right?
Yes.
Thank you.
Mr. Bhandari, now, assuming that this power to make law under 191 is an enabling power, the subject matter is the practice and procedure of the court. So, could it be said that the power of the court, the rule-making power, in respect of this subject matter, and the power, if this is an enabling power of Parliament to make a law, are coterminous, meaning they extend over exactly the same area?
My lord, I would say no, because then once Parliament covers everything, then there is nothing.
I'm not saying. What I'm saying is, whatever is the subject matter of the practice and procedure of the court has the power to make rules in that regard.
My lord,
if law as used in 191 is an enabling power, it operates on the same subject matter, and the area therefore is the same.
If it is used as an enabling provision,
yes.
Then yes.
But then if that is so, you have just told us, and quite rightly so, that in exercise of rule-making power, the Supreme Court cannot give a right of appeal.
Can't.
So therefore, if the two powers are coterminous in respect of the subject matter, my question to you is, how can, if it is an enabling power, how can Parliament use Article 191, because that is what is referred in the
Yes.
preamble, how can it use that power to confer a substantive right of appeal? How is that possible?
It can't. It can't be.
So I agree with the comment made by my little brother, but and just adding to that, to the extent of practice and procedure, if we were to take 191 to be enabling power, then to the extent of practice and procedure, the law is correct. As far as the substantive provision of appeal is concerned, we'll have to look the other way, and then we'll have to look at 55, which, as I had earlier said, is already full of confusion and not very clear. So that's that. But as far as the law and practice and procedure is concerned, if we were to imagine that 191 is an enabling provision, then the law passes the test, the committee and all the other provisions, except the substantive part of appeal, which is still unanswered, and we wait for the others to
My Lord,
explain.
even then, that's why I added a caveat at the outset that even if it is an enabling provision and enables Parliament to enact a statute for rules and procedure on the basis of 191 itself, it will still be subject to some all overarching constitutional principles. Now, one constitution.
Fair enough, that's fine.
My Lord, allow me to finish this. One overarching constitutional principle, which, in my humble opinion, and that's what I've submitted, has acquired the status of a constitutional convention, is the power of the Chief Justice to form benches. Now, I am not for a moment saying that should not be revisited. I'm not for a moment saying that. I'm saying that since that has achieved the status of a constitutional convention, that constitutional convention is being continued by virtue of the provisions of Order 11 of the Supreme Court rules. Therefore, the Parliament can't undo that, as held by Baz Mohammad Kakar. Your lordships will have to do that in exercise of rule framing power.
So after your point, suppose if we were to take 191 to be enabling power, then we look at the law, and we look at the law, then it has to pass the muster of fundamental rights and all. And yes, I would agree with my little brother who would refer to my earlier order relating to the committee deciding the thing, which is I'm very clear on that issue. There could be either that has provision, could be, speaking for myself, read down, or we're not sure whether at all they judicially decide this question or administratively decide this question. One would imagine because it's a committee, it is more of an administrative thing.
Yes.
That's a snag which needs to be rectified, but that's that.
Yes, yes. So,
Can I just place a conundrum before you, and if you can respond to it?
another one, my Lord.
This is the first one. This is the first one that directly affects me.
Okay.
Since everyone is very kind on both sides of me, and all of you are very kind, let's suppose I, in the person of the Chief Justice, become very unreasonable. All my colleagues ask me to call a full court meeting to amend certain rule which requires amendment, okay, or some other issue. I say no, I will not do it. So there is nobody can do anything about it. Very bad. So when we talk about there are two arguments. One is trichotomy of powers. Then within a particular constitutional body like the Supreme Court, well, yes, I can go along with the first one, but then are you also propagating the omnipotency to the Chief Justice, or as used to be criticized, the Lord Chancellor of, and the equity varies with the Chancellor's foot? So suppose I become unreasonable, tough luck to all of you, to everyone in Pakistan, tough luck. Right?
No.
How will you resolve this?
My Lord.
Parliament has said, well, you may not like it, Mr. Chief Justice, but we have made an attempt to resolve it, because you are never going to do it. You are never going to do it. And you, by your conduct, have shown you are never going to do it. So you can say, no, we must persist on omnipotency to the Chief Justice, the person of the Chief Justice, and he can do no wrong. And let him do is it democratic? Is it just? Is it forget the Constitution of Pakistan for the time being. I'm talking now of greater concepts like justice and fairness. Does it meet? We talk about Islam, but surprisingly enough, not one person has mentioned Islam here. Does Islam even permit this?